Checkmate. Hello and welcome back to this channel. I hope you guys are having the best day. Judgment Day is here and it ends with justice. Justice for Wayfarer for having to put up with all of this since signing Blake Lively on in 2022. Can you imagine? Welcome back to this channel. My name is Mandy Magnan. I'm an actress, writer, producer, director in Toronto, a movie reviewer, pop culture, and of course, a YouTube commentator for everything It Ends With Never. Well, it happened. The day of judgment is upon us, and Wayfarer absolutely came with everything. Grab your emotional support lip gloss. We are getting into it. You are in frame with Mandy Magnan. Okay, there is a lot to go over. So what I'm thinking I'm going to do is a 4-part series because once I show you everything that's been submitted, it's going to take about that long. I was thinking about doing it all live, but honestly, it would probably be like a 7-hour session. So what I'm going to do is break it down into a 4-part series. And then tomorrow, Friday at 5 p.m. from 5 till 7 Eastern time, I will be going live to go over anything maybe I missed or answering any of your questions or revisiting certain aspects of the case. So if that sounds good, let's go into it. I just want to show you exactly everything that was filed so you kind of understand. It's like over 100 exhibits. There's tons of declarations. I mean, congratulations to the Wayfarer parties and their lawyers because the work that they've done for this summary judgment is, I mean, chef's kiss. I did make a video this morning already with the videos that have been submitted. We don't get all of the videos and we don't get everything because Miss Lively has put confidentiality and a lot of redactions on certain things, which we will talk about. But first, let's look over the court listener and you can get a visual of what we're working with here. We start here on November 13th with Rule 56.1 statement that was filed by all the Wayfarer. Then there's a declaration of Mitra, who is one of the lawyers. She was also at the It Ends With Us premiere and stuck in the basement because of Blake Lively. There's a memorandum of law in support of the motion for summary judgment, which is actually what we're going to look at first. Then there is the declaration of Justin Baldoni. There's a declaration from Jamie Heath. There's also a declaration from one of the attorneys, Alexandra Shapiro. And then look at the attachments. Over 100 exhibits. There is actually 138 exhibits attached. Then they do have a letter motion to seal. And Jennifer Abel has brought in a new lawyer, although I'm not sure they really need any at this point because wait till we get into it. But there is a notice of appearance by a David Aberman Gold on behalf of Jennifer Abel. And yeah, that's it. So let's go. And I just want to say quickly, whether you subscribe to this channel or any of the other content creators or commentators following this lawsuit, give them a big round of applause because the work that we're having to do today, I'm sure going into the entire weekend because there is so much here. It takes a lot of time, a lot of resources, and it's a lot of work. So just make sure you give them a little bit of extra love today or a round of applause and support them because, you know, this is wild, but we are here. Summary Judgment Day. Wayfarer did not disappoint. I feel like they got lively in all corners with actual evidence, deposition testimony, and video footage. I already showed a video footage this morning of Blake Lively kissing Justin Baldoni, which was not in the script, improvising a kiss, as well as her sitting on the floor talking about how sexy her shoes are and sexy, sexy, sexy. And it's like, but then you got mad that Justin Baldoni used the word sexy twice around you. Girl, right now you just better wrap it up, okay? And I hope the only dollar you're now providing to those lawyers who I'm sure you've paid now over $50 million to is to close this thing immediately because it's over, at least in my opinion. I mean, of course, we'll have to see what the judge says and then they have to counter and da-da-da-da-da. But there's a lot of things in here that are undisputed. So without any further ado, let's dive in straight away to the memorandum of law filed by the Wayfarer people. Oh, my bad. I just want to go over this really quickly because you are going to see a lot of redactions and a lot of things sealed. And this is a letter that Wayfarer submitted into the court late last night before filing all of their summary judgment and Rule 56.1 motion. And it reads like this. On behalf of the Wayfarer parties, we write pursuant to the court's individual rules to respectfully request that the court seal portions of the Wayfarer parties' motion for summary judgment and associated exhibits. The papers refer to discovery material designated confidential. To be clear, the Wayfarer parties do not believe that much of this material should be sealed, especially to the extent it includes Blake Lively's contemporaneous communications with others about her work on the film, which are central to the dispute at hand. Nevertheless, in accordance with Rule 4.b of Attachment A, the Wayfarer parties request that the court not rule on this letter motion to seal for 1 week so that the parties can meet and confer, and so that any party may file motions for continued sealing if they so choose. Of course, Blake Lively wants her communications sealed. We haven't seen any of her communications so far. It's been a very one-sided case, but it just is what it is. Maybe they'll come unsealed, maybe they won't. Maybe this will all be over before we even know it. Who knows? But this is the memorandum of law in support of the Wayfarer party's motion for summary judgment. Yeah! And buckle in because this 4-part series is going to be long. It'll probably be about an hour per video. Each document is about 80 pages. I have gone and highlighted the most relevant part of this one. And they're not playing, okay? They're throwing everyone under the bus, including Ryan Reynolds, obviously. Introduction. Blake Lively, an immensely powerful A-list actor, agreed to act in a film adaptation of It Ends With Us, a book with themes of sex and domestic violence. During the initial stages of filming, she voiced objections to certain on-the-set behavior she did not like. That behavior, involving no more than miscommunications and awkward comments, falls well below the threshold of any claim of sexual harassment or other legal wrong, especially in the context of collaborating to make a sensual and provocative sexually charged film. Regardless, Lively's concerns were heard and fully accommodated. It is undisputed that whatever she claimed to have experienced ceased. Filming continued during all future stages entirely without incident in an environment Lively touted as blank and blank, including the filming of all intimate scenes involving Lively herself. Even Lively's then lawyer said no formal HR process, let alone litigation, was necessary. Any issues had been successfully resolved. Months then went by, but as the film was edited and moved towards its premiere, something else happened. Lively asserted control of the film and took aggressive steps to minimize Justin Baldoni's role, even though Baldoni had conceived, directed, and co-starred in the film, and it had been produced and co-financed by his production company, Wayfarer Studios. Lively took all the credit. She wrote to the Producers Guild of America, it's redacted. At the same time, Lively and her actor husband, Ryan Reynolds, disparaged Baldoni to their famous high-powered friends in Hollywood and Baldoni's talent agency. As the film's premiere approached, Lively became increasingly hostile. She excluded Baldoni from marketing materials, press, and promotion for the film, snubbed him on social media, urged Sony to eliminate his A Film by credit, and even tried to exclude him from the premiere. In light of these astounding developments, and not the minor concerns about the on-set behavior raised and successfully resolved many months earlier, Baldoni sought the advice of a crisis management PR firm, as any responsible person in his position would do. He wanted to minimize fallout from media coverage of Lively's increasing attempts to alienate him from the film. He did so for the benefit of both his professional reputation and the newly released film. He relied on media professionals to boost his image and assure that any coverage would be balanced and accurate. None of that is against the law. Aided by two of the world's largest litigation firms, Lively now seeks to create causes of action where none exist. She cannot show the behavior she disliked was caused by her sex or gender, a basic prerequisite for her sexual harassment claims. She alleges Baldoni's resort to public relations professionals was retaliation for complaints she had raised. This ignores the large temporal gap, not to mention the many intervening events between her raising of concern. There can be no claim for retaliation based on purported complaints raised in the distant past. Nor did Baldoni and his co-defendants engage in a defamatory smear campaign. It was not illegal for Baldoni to promote positive content about himself or truthful narratives about various events. That Lively's reputation may have suffered is a result of her own ill-advised public statements and actions. This is the dispute about Hollywood reputations, not genuine legal wrongs. It does not belong in court. Woohoo! Statement of facts. Justin Baldoni is an actor, director, producer, and author with significant experience in addressing gender issues, including in 2 published books and a podcast devoted to questions about masculinity, all aimed predominantly male audiences. This is what I've been saying since the beginning. He has never done this for women. It's always a male audience, and he wants men to change. And he said that so many times. He wants to address men, and his target audience is men and how they can change and better to love the women in their lives. But Blake Lively and her PR team tried to twist that on its head and say that he's like doing this for women and he's so pro-feminist that, you know, all of that stuff. Anyway, he obtained the rights to produce a film on Colleen Hoover's best-selling novel, It Ends With Us. Baldoni's production company, Wayfarer Studios, which specializes in films designed to promote social change, initiated work on films alongside Sony, with Baldoni set to serve as the film's director and lead male actor. Because the story focused on issues of domestic violence, Baldoni and Wayfarer partnered with MEMORANDUM More, an organization dedicated to ending domestic and sexual violence, and agreed to contribute a portion of the film's proceeds to support survivors of abuse. In early planning, the parties agreed the film's publicity needed to center upon and carefully handle these serious themes. Lively chose to take a lead role in a sexually charged film with adult themes. In December of 2022, years into the film's development, Blake Lively, a well-known prominent actor, was cast as the female lead. She understood, nevertheless, based on the script and before she accepted the role, that the film would include sexual content and address domestic violence. Prior to filming, Lively reviewed notes from a female Sony executive stating that the audience was expecting something blank with, and I'm sure that's like sex and violence or violence and sex or something, right? Lively worked as an independent contractor, but no contract was ever formed. The parties never executed any contract concerning Lively's role. Negotiating began in December of 2022 between It Ends With Us Movie LLC, an entity Wayfarer Studios formed to produce the film, and Blakel Inc., a loan-out company lending Lively to perform in the film. An offer letter dated March 17, 2023, set forth the basic financial terms, which promised Lively a $1.75 million fee plus various bonuses, but she did not contain any terms regarding sexual harassment. The parties also worked towards a separate long-form agreement to include other material terms. It Ends With Us movie's obligation under the offer letter were expressly subject to a condition precedent, namely full execution of an agreement in a form reasonably acceptable to all parties. It Ends With Us movie counsel circulated a draft of the anticipated long-form agreement between It Ends With Us movie and Blakel Inc., the actor loan-out agreement, in May 2023. The draft stated conditions precedent, including full execution of the agreement and receipt of an executed document known as an inducement. It also had a merger clause specifying that it constituted the entire agreement between the parties, a provision prohibiting special or consequential damages, and certain other standard terms, including one stating there would be no actionable breach for any conduct unless notice was provided and cure not affected within 30 days. Girl, did you even read your own contract? Oh my gosh. My jaw is on the floor. The same or similar terms endured throughout the drafting process. As work proceeded on the film, payments were made pursuant to the offer letter. The parties continued to negotiate the terms of the long-form ALA into July 2024, but Lively herself continued withholding her signature to avoid being bound. From the outset, Lively sought increased control over the film. Although recruited to act in the film, Lively immediately assumed an active role in production and in developing the film's script, even before filming began. Among other things, she provided Baldoni with a rewrite of the rooftop scene in which Baldoni's character and Lively's character first meet. She explained that her version of the scene was blank. It retained a line from the book blank. In messages to Baldoni, Lively referred to her revised draft as featuring blank. And this is so strange because we have all of those text messages and like the original counterclaims and stuff. So why are these blanked out? I don't know, but it's very alarming to me that Blake Lively last week filed motions to Melissa Nathan for sanctions for improper redaction, but then her herself made sure that Wayfarer redacted all of this stuff. Okay, like we'll see if this all gets unsealed, but anyway, in messages to Baldoni, Lively referred to her revised draft as featuring blank. Lively took special steps to convince Baldoni to accept her version of the scene. I'm sure this is where they talk about the text messages, that 14-paragraph unhinged text messages, as well as Taylor Swift, right? After the meeting, Baldoni told Lively he would have gladly accepted her revisions, even without urging from, and I'm sure that's Ryan Reynolds and Taylor Swift. Lively has since disclosed that Reynolds, not she, rewrote the scene. This episode, which occurred even before filming began, was the set of a series of events in which Lively relied on an array of Hollywood friends to increase her control over the film while denigrating Baldoni to them along the way. Before filming began, Lively took additional steps to influence the direction of and take control of the film. At her request, Wayfarer abandoned plans to film the movie in Boston, where the novel takes place, and relocated the set to New Jersey, near Lively's home. Wayfarer also agreed to change the start date and schedule to accommodate Lively's other professional and personal commitments. Lively raised concerns about her physical appearance. Having recently gave birth, Lively expressed concerns to Baldoni and others that she redacted. When Lively asked Baldoni responded kindly. All of this is redacted, but it's pretty much she sent him a text saying, hey, can we change any of the scenes into phase 2 because, I'm feeling very insecure. And he's like, no worries. Like, don't worry. That's the last thing you should be worried about. Whatever, right? Meanwhile, Lively raised the same concerns to her agent, noting, redacted. Lively's communications reflect her frank awareness that the film was intended to achieve a certain sexualized imagery. She told her agent, redacted. Lively was equally frank with Baldoni, redacted. She added, redacted. So anything Blake said to anybody else, she's not allowing us to see it. She noted them as being confidential. Okay. Wayfarer, It Ends With Us movie, and Baldoni took steps to create a safe set. Wayfarer had a set of industry standard policies and procedures in place to prevent harassment, discrimination, and retaliation. Its employee handbook expressly prohibits such conduct and encourages employees to report violations. To enforce these procedures, Wayfarer had an HR department with dedicated staff. That's more than what Stephanie motherfucking Jones had. I'll tell you that. She didn't even have HR. Prior to filming, It Ends With Us movie held an anti-discrimination training administered by an outside law firm. It Ends With Us movie also included a worker safety hotline on its daily call sheets. Lively benefited from other productions as well. The offer letter provided that she would not perform any nudity stimulated sex without her prior written consent and without negotiating an execution of a formal nudity rider. In April 2023, before filming began, It Ends With Us movie hired Elizabeth Talbot to serve as the intimacy coordinator for the film. Lively was given the opportunity to meet with Talbot a month before filming began, but declined. Before shooting began, Talbot considered the content of anticipated intimate scenes and suggested details and clarifications. She also spoke with Lively about Lively's boundaries. When Lively expressed reservations about intimate scenes, Baldoni volunteered to keep the focus on his own body so that scenes could be, and then it's redacted, but I'm sure that's like shot, without showing Lively's body, whatever. How are you signing on to this role and then not wanting to do any kissing, simulated sex scenes, making out? Are you okay? Like, you shouldn't act. If you just want to be in big blockbuster movies, that's fine. But it's very strange because then she went from this film to going to do Another Simple Favor where she literally does it with herself. So it's like, okay, I don't know. I wouldn't trust her on my set, that's for sure. Prior to shooting, Lively and Baldoni were both provided with nudity riders detailing their consent and boundaries concerning intimate scenes. In the first phase of filming, Lively did not film any intimate scenes, but voiced objections to certain behavior. Filming began on the set in New Jersey on May 15th, 2023. It stopped on June 14th, 2023, due to strikes by the Writers Guild of America and SAG-AFTRA. None of Lively's intimate scenes were rehearsed or filmed during this period. Can you imagine? She didn't even film any scenes. No intimate scenes. They weren't even rehearsed. And yet she came up with that plan with that 17-point list of demands. But yet there wasn't. Okay. However, all the incidents Lively now characterizes as compromising a hostile work environment occurred prior to or during the first phase of filming. Lively's stated concerns, even if accepted as true, all involve incidents of relatively low level or innocuous behavior that, considered separately or together, fall short of actionable discrimination or sexual harassment. For instance, Lively claims Baldoni described his genitalia in their first meeting before she had agreed to join the film. This is a hyperbolic lawyer spin on what really happened. And then you have it all redacted. Such a statement is obviously not justification to bring any claim in court. Indeed, Lively herself seemed unfazed. I think that was probably them talking about how they're going to do sex scenes, and if they're going to use a pillow, if they're going to do anything, who knows what it says in there. But it's obviously it wasn't at all how Blake Lively claimed it to be. She had raised the subject, did not complain to anyone at the time, and after the meeting, her husband sent Baldoni an effusive message saying, so Ryan Reynolds added again, Lively also accuses Baldoni of fat shaming. This allegation is based on a single instance in which Baldoni, who had chronic back problems and anticipated a scene in which he would have to lift Lively up, privately asked a personal trainer he had consulted with, who also trained Lively, about her weight. He did so discreetly, outside the workplace and outside of Lively's hearing. But even if this inquiry was, as Lively now portrays it, a sly criticism, any petty slight that might have arisen when the trainer, on his own initiative, repeated the comment to Lively is simply too trivial to constitute sexual harassment. Lively further accuses Baldoni of adding gratuitous sexual content to the script before filming began. The evidence shows, however, that the scenes were redacted to align with the explicit female-authored book on which the film was based. Baldoni asked the female intimacy coordinator to review them with Lively. To the extent Lively objected, scenes were revised or removed. Moreover, Lively herself rewrote other scenes to boost their sexual vibe. Lively claims Baldoni improperly used the word sexy to refer to her wardrobe on one occasion and to that of another actor on another occasion, and that at one point he complimented Lively's own personal low-cut outfit. Such passing, sporadic comments, while perhaps ill-advised, are not outrageously offensive in an environment where professionals are working closely together to make a deliberately sexually charged film. Lively also asserts that Baldoni at times alluded to his own sexual and marital experiences. Again, such exchanges are hardly surprising given that Lively and Baldoni were collaborating and communicating daily about how best to portray various adult and marital themes. Lively also claims Jamie Heath, Wayfarer's CEO and one of the film's producers, momentarily glanced at her naked upper body after she permitted him to come into her trailer while she was having makeup removed. Lively says she instructed Heath not to look at her, but at some point during their brief conversation, redacted. And I think this is where Heath looked at her in the eyes. Whatever fleeting mishap may or may not have occurred, it is being characterized as sinister only in retrospect. At the time, Lively said, "I know you weren't trying to cop a look." Lively also objected to being shown a video image relating to Heath's wife's home birth, incorrectly believing it was pornography. Then it's redacted. The film includes an important scene between Lively and Baldoni's characters surrounding the birth of their child, and Baldoni and Lively had discussed the scene before Heath shared the video image. Lively includes an assortment of other objections in her complaint, including that she contracted COVID on set, that after Lively told Baldoni she had never seen porn, he shared that fact with others. That at one point, Baldoni shared a personal story about being pushed past his own consent boundaries, an experience he has discussed publicly, including in his published books, and that there was too much hugging on set. Ooh, not the hugging. Yeah, the hugging gets me every time. Oh my God, you guys like each other so much. There's too much hugging. I mean, if you don't want to hug someone, just don't hug someone. But anyway. Lively's objections were addressed before and during the filming hiatus. Although Lively's descriptions of events is disputed, what is undisputed is what Lively's objections were resolved as soon as they were raised. Lively chose not to file any formal complaint, instead redacted. Consistent with that approach, after Lively and her husband chastised Baldoni for inquiring about her weight, the issue did not recur. Lively objected to certain sex scenes and Baldoni revised or eliminated them accordingly. On June 1st, 2023, a few weeks into shooting, Lively met with Baldoni and Heath and reviewed various matters she was unhappy about. Baldoni and Heath apologized for Lively's discomfort. Evidently, that was enough to resolve the issue. Lively has not identified any incident after that meeting that she claims constitutes sexual harassment. On November 9th, 2023, 5 months after filming had stopped due to the strikes, Lively, through her entertainment lawyer, sent a list of protections she wanted observed in connection with any future filming. You know what I think happened? I think she signed on to this role, and this is just coming to me, so I know I'm digressing from the script here, but I think maybe Ryan Reynolds didn't understand what was the movie and what was the script. And I think once Blake Lively started shooting it and going home and telling Ryan about her day, there was issues in the home. And I don't think this is going to make it any better. And if we're speaking about domestic violence, I really hope that the Lively Reynolds house right now is, taking care of themselves and their children. As much as, we can all joke and kiki here. If there is like an issue with power in their relationship, this is not going to go good. And I have said from the beginning that I feel like Ryan Reynolds is at the top of this entire thing. So I'm just saying that the way he's always like interjected himself and attacked Justin and changed scenes and had scenes removed, and it just seems like maybe a controlling husband and a delusional narcissistic wife, in my opinion. Let's continue. Lively's lawyers said a signed agreement to abide by the protections would suffice in lieu of a more formal HR process. Lively did not commence any litigation or file any formal complaint, though her lawyer noted she reserved all legal rights. The requested protections largely replicated protections that were already in place, such as the use of nudity writers and an intimacy coordinator. Other protections implicated conduct Lively herself had engaged in during the earlier phase of filming, such as improvising kissing in scenes, commenting on her own physical appearance and that of others, and hugging other cast members. On July 4th, Lively held a production meeting at her apartment. Lively read a list of grievances from her phone that included, in addition to incidences discussed above, a demand that Baldoni not speak to her dead father, mentioning his own religious beliefs, or have private multi-hour meetings in Lively's trailer with Mr. Baldoni crying. Lively also demanded notice of COVID exposures on set. On or about January 19th, 2024, Heath, acting on behalf of It Ends With Us movie, signed the productions as incorporated into a rider to the unsigned ALA between It Ends With Us movie and Blakel Inc. Lively refers to this document as the Contract Rider Agreement, the CRA. But the CRA does not include any admission of improper conduct. It is a forward-looking document concerning behavior once filming resumes. The second phase of filming proceeded without incident. Filming resumed on January 5th, 2024 and concluded on February 9th. Lively raised no further objections and told another female cast member the set was professional. Whatever issues had been raised months before had fully been resolved. Lively used her famous friends and connections to take control of the film. Shortly after filming wrapped, Lively told Sony she would not agree to promote the film unless she was permitted to participate in the edit. Thereafter, she amassed an enormous level of control over the film. When Lively received pushback, she recruited famous friends. And now we'll see who those famous friends are because, of course, it's frickin' redacted, to support her while disparaging Baldoni to them. We'll never, it's all redacted as to what those friends said and what happened. Lively also insisted on changes to the film's credits and removing Baldoni's film by credit altogether. In a June 25th, 2024 letter to the Producers Guild of America, it is a remarkable document, and then we don't know what it says. Lively stirred up negative press about Baldoni and the film. Apparently not content to have wrestled directorial and editorial control from Baldoni, Lively set out to destroy his reputation and alienate him from his own film. Lively and her famous husband unfollowed Baldoni on social media, encouraging the press and fans to suspect a feud. Unsurprisingly, the press took notice, but Lively wanted more. On July 22nd, then it's redacted. Ultimately, Baldoni was allowed to attend so long as he left the red carpet before Lively arrived, waited in a basement while she and her famous friends were photographed, and then watched the film in a separate theater. Baldoni and Wayfarer then hired a crisis management team. It was in the context in late July 2024, over a year after Lively's concerns about the on-set behavior had fully resolved, and faced with a new set of concerns relating to the media coverage surrounding and following the film's premiere, that Baldoni and Wayfarer first entertained the concept of hiring a crisis PR team. Even as the negative press intensified, Baldoni's team, led by Heath and his long-lasting publicist Jen Abel of Jonesworks, agreed that it would be a mistake to fan the flames and that blank. On July 25th, Baldoni and Heath met the agency group TAG, Melissa Nathan's PR firm, to discuss retaining the firm for crisis management. In subsequent messages, Wayfarer reiterated that it did not want to take any offensive steps and that Nathan would not be redacted. On August 2nd, 2024, TAG circulated the scenario planning document that had been the subject of much of Lively's ire. As the title suggests, the document simply laid out a menu of possible options. It was not an agreed upon plan of action. Immediately after the premiere, numerous outlets published stories about the feud between Lively and Baldoni. That was in part prompted blank. And I think it's probably in the blank area. It says because Leslie Sloan was speaking, they blah, blah, who knows, because they were in the basement. But I think it was prompted by Blake Lively's own team. Baldoni's PR team, led by Abel, Nathan, and Tag, distributed positive information and stories about Baldoni and worked to mitigate or minimize negative ones, standard operating procedures for PR professionals. Baldoni himself made numerous positive public statements about Lively. On August 7th, Abel told Nathan that she was still waiting on a green light from Heath to put the social combat plan into motion. So they didn't even put it into motion yet. On August 9th, Wayfarer engaged Street Relations, Jed Wallace's firm, to monitor social media concerning Lively, Baldoni, and the film. Contrary to Lively's claims, Wallace testified blank, at the same time blank, hoping to avoid any adverse publicity that could interfere with the reception of the newly released film. Lively suffered backlash. The attention commanded by Lively's star power and by news of the purported feud was a double-edged sword. By virtue of all the coverage, she was put under a very public microscope. In August 2024, she experienced a massive outpouring of negative sentiment, but the undisputed evidence shows Lively's own missteps were a significant driver of that response. Several press outlets picked up, for example, on Lively's decision to cross-promote a serious film about domestic violence with, among other things, her husband's summer superhero blockbuster, as well as her own hair care and beverage products. Lively privately blank. Lively also came under fire for the past missteps, including, this is probably getting married on a plantation, doing blackface, insulting women interviewers like Flossom Talk, I mean, there's so many examples that we can go on. But yeah, her past missteps for, telling her co-star, telling the entire world that her co-star was born in a cage when she was born in a jail. Like, you know what I mean? Okay, like it didn't take a lot of Googling searches to bring up your missteps, okay? Lively does not dispute that any of these events actually occurred. She merely insinuates that defendants had a role in bringing them to light. The evidence does not support her headline claims. After months of scorched earth discovery, backed up by a pounding drumbeat of almost daily motions to compel, Lively has been unable to identify any instance in which any defendant distributed or promoted any false story about her, even after subpoenaing dozens of content creators. Her interrogatory response summarizing the evidence of what she described as a highly orchestrated smear campaign reveals a surprising truth. What Lively primarily objects to is Baldoni's effort to defend himself, whether by promoting positive stories or trying to suppress negative ones. But that is not retaliation. Even when certain defendants contacted the press about Lively in August 2024, their efforts were far from the sophisticated internet takedown Lively touted in the press. The few instances in which the evidence suggests any defendant spoke to the press about Lively all involved truthful reference to her actual conduct, or to that of her husband, or the sharing of opinions about that conduct. Lively has also claimed defendants used a network of bots to bring her down. Contemporaneous documentary evidence shows that Baldoni himself repeatedly confirmed with both Abel and Nathan that they were not using bots or fake accounts. Nathan in particular assured Baldoni the backlash was organic. She's blown up herself by her own actions. Once media goes in, they go in. You did not do any of this. We did not do any of this. This is all organic, etc., etc., etc. Baldoni later discussed with Nathan that he had no intention to make Lively an outcast and was praying for her and her family. Oh, Justin. Miss Lively and Reynolds smeared Baldoni once again. Ironically, Lively's cry that Baldoni tried to bury her more accurately described her own efforts to tar him. Beginning on August 9th, just one day after Lively alleges the smear campaign began, and then it's all blank. 4 days later, all blank. But we already know they were hard at work. They were hard at work. That's what we've been talking about. The smear campaign was on the other side, baby girl. It was Lively doing it. Lively then used the sham litigation to obtain the private messages of Baldoni's publicist Jen Abel, using a shell company as a bogus plaintiff. The company filed claims against 10 anonymous Doe defendants, and working behind the scenes with Abel's former employer, Stephanie motherfucking Jones, invoked a New York State court subpoena power to obtain Wayfarer's confidential records from Abel's personal phone that Lively would not have otherwise been legally permitted to obtain. On December 21st, 2024, the New York Times published a 4,000-word article entitled "We Can Bury Anyone Inside a Hollywood Smear Machine" that relied on the documents Lively had obtained through the sham lawsuit, as well as an admin complaint she filed the day prior. The article asserted Baldoni and Heath had violated Lively's physical boundaries and made sexual and other inappropriate comments to her, and then instituted a retaliatory smear campaign. Weeks before the article came out, blank. Around the same time, Lively conveniently dropped her New York State court lawsuit, confirming it was not filed in good faith and had only been used as a ploy. Wait a second. Confirming? So Blake Lively confirmed it was not filed in good faith and it was only used as a ploy? Yes, Vincent! You girls are going down for what you did. Lively initiated this litigation. In December 2024, 18 months after the minor issues she raised about the on-set behavior were fully and successfully resolved, Lively launched this dispute with an admin complaint and then fanfare of her New York Times headline. The behavior she previously regarded as not requiring any formal HR process was now presented by two large, sophisticated global law firms as sexual harassment of the gravest kind. And Baldoni's natural defensive effort, after being sidelined from his own premiere, to manage his own and his film's reputation by employing experienced PR professionals, was now recast as retaliation against Lively for raising purported sexual harassment concerns. Lively's numerous claims against numerous defendants cannot withstand scrutiny. Judgment should be entered for defendants on all claims. The argument. For the reasons set forth below, Lively's claims all fail. This motion also incorporates the argument in defendant motion for judgment on the pleadings, including that extraterritorial application of California statute is improper because, as the undisputed facts show, no alleged incident of harassment took place there. Lively cannot prove any actionable sexual harassment counts, which is her counts of 1, 3, 6, 7, 8, and 13. This court, as well as many others, have pointedly observed that in evaluating what constitutes actionable harassment or a hostile work environment, context matters. Comments made on the set of filming a movie about adult themes may have a different material effect from similar comments made in a routine office setting. Lively knowingly took a lead role in a provocative, sexually charged film based on a book famous for its intense, intimate scenes. When viewed in context, no reasonable juror could find that the handful of comments and miscommunications Lively has mustered amounts to sexual harassment. Lively cannot prove severe and persuasive harassment. Title VII, FEHA, and the UNRUD Act do not address trivial slights nor prescribe a general civility code for the workplace. The litany of minor grievances Lively cobbles together falls far short of the requisite level of being severe or persuasive enough to create an objectively hostile or abusive work environment. Isolated acts, unless very serious, do not meet the threshold of severity or persuasiveness. The sporadic use of abusive language, gender-related jokes, and occasional teasing are not actionable harassment under federal or California law. In separating low-level objections from legally cognizable wrongs, courts consider the totality of circumstances, the frequency of the discriminatory conduct, its severity, whether it is physically threatening or humiliating, or a mere offensive utterance, and whether it is reasonably interferes with an employee's work performance. It is not enough for Lively to say that she personally found something Baldoni or Heath did objectionable. Both an objective and a subjective standard must be met to sustain the claim. Lively's claims premised on a few purportedly offensive utterances and on-set mishaps do not satisfy these standards. That Baldoni, in directing particular scenes, twice used the adjective sexy to refer to how female actors appeared in their assigned wardrobe is hardly surprising given the sexually charged nature of scenes in the film. The banality of such conduct and its general low-level offensiveness is underscored by Lively's blank during her work on the film. Video footage confirms that Baldoni's use of the word sexy in reference to Lively's wardrobe was entirely unremarkable. Lively was not scantily clad, but dressed in an oversized fleeced onesie, nor was this anything that might remotely approach flirtation. Rather, both she and Baldoni were working at the time, surrounded by actors and crew. Baldoni's expression was neutral and not ogling or suggestive. On top of that, Baldoni apologized if his remark was inappropriate, and Lively responded by saying, "All good." Even in routine office settings, such conduct is not actionable. For example, the Second Circuit held a high school teacher's claims that her male supervisor occasionally commented on her physical appearance and participated in a bet with 3 other male employees as to when he would be able to engage her in sexually explicit conversations. That was insufficient. I think that's kind of crazy, but I mean, I'm not a judge. Similarly, claims that a senior employee told plaintiff that her clothes were sexy and that her hair was beautiful, sometimes blew kisses at the plaintiff, as he did to all his employees, once sent plaintiff an inappropriate email and made sexual jokes, that was insufficient. Likewise, a file clerk's claim that her supervisor complimented her hair and eyes, commented that she looked good in tight pants, and referred to her as a bitch twice, that was insufficient. Lively's other complaints are equally deficient when viewed in context. It would be one thing if Lively and Baldoni were 2 insurance executives reviewing actuarial figures on a spreadsheet, and out of nowhere Baldoni alluded to his marital or sexual experiences or to a prior pornography addiction. It is quite another thing, though, because Lively and Baldoni were discussing these issues in the context of creating intimate scenes and adult themes in the film they were making together. Lively always had complete control in approving any additions to the script concerning intimacy, as well as access to a female intimacy coordinator. And she raised no concerns throughout the entire period in which the movie's most intimate scenes were filmed, which was in phase 2, baby girl, okay? Lively's complaint that Baldoni inquired about her weight similarly falls short. He didn't make the comment in the workplace or in the presence of any cast or crew members or even Lively herself. It had no effect on the workplace environment. Someone else communicated it to Lively, not at Baldoni's request and independent of any activity related to the film. Sexual comments did not amount to verbal abuse or harassment in as much as the subjects were not even present to hear the speaker's offensive remarks and apparently had no awareness of what had been said. In McSweeney, this court rejected Title VII claims. It observed that calling someone a housewife or commenting on a coworker's breast implants would be highly offensive in a run-of-the-mill office. At the time, however, in connection with the reality TV shows The Real Housewives of New York City, those comments had a different ring. This court held that even such obnoxious and insensitive comments did not rise above the level of a petty slight. California Supreme Court has similarly observed the circumstances that this was a creative workplace focused on generating scripts for an adult-oriented comedy show featuring sexual themes is significant in assessing whether the plaintiff had viable harassment claims. The plaintiff's claims that male writers made graphic comments about having sex with an actress on the show only once or at least twice in 4 months was not sufficient to support her claim that hostility towards women permeated the workplace. Lively's claims suffer from the same fatal defect. Lively was not targeted on the basis of her gender. To sustain a sexual harassment claim, Blake Lively must show that the offending conduct was motivated by her gender, that she was treated a certain way because she was a woman. The critical issue Title VII's text indicates is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. Lively cannot show that here. The basis of many of her claims have nothing to do with her sex. For instance, Lively contends that there was too much hugging on the set. She does not claim, let alone prove, that hugging was gender specific. The undisputed evidence, including video footage, shows both men and women being men and we're here because of hugging. Okay. On set, both men and women were being hugged, okay? A lot of people were hugging. I've worked on a lot of sets, and yeah, you hug, okay? Like, you go in, it's a big family, especially when you're doing really intense, intimate scenes, whether that's sexually intimate or whether that's violence or whether the more crazy, like the more emotionally charged and violent and sexual the script is and the places you have to go dark, the lighter the set has to be, because you're already, in my own opinion, like when I worked on like horror movies and stuff, when the cameras weren't rolling, it was actually a more like fun, jokey, blah, blah, blah kind of set because of the places you had to go in the work. I feel like it was like just such a load off. So, I mean, hugging, perhaps there was a general over generosity of spirit among people on the set. Oh my gosh, they really have to like explain being so nice to each other. But such facially sex-neutral incidents, even if they made Lively subjectively uncomfortable, do not create an environment that a reasonable person would find hostile or abusive. Baldoni spoke with Lively about topics like sexuality, consent, and pornography, not motivated by her gender, but because she was his co-lead and collaborator in a film exploring adult themes. It is undisputed that Baldoni has spoken openly about such topics to large audiences of men as well as women, including in 2 published books and a frequently broadcast podcast. No evidence suggests he singled out anyone for differential treatment on the basis of gender. Moreover, it is undisputed, and then we have a whole bunch of blank stuff. And then it does say, meanwhile, Lively advocated, and then it's blank. So we'll have to see what we can see in these exhibits. Against the backdrop of a film devoted to achieving a certain sexy aesthetic, a project Lively embraced and advanced, it is impossible to see occasional sporadic references to sexuality as specifically directed towards either gender. Nor do the 2 aligned instances involving Keith reflect any gender motivation or animus. Lively was shown a fragment of a video depicting family members, male and female, and a newborn child, not because she was a woman, but because she had acted in an important birth-related scene in the film, the details of which she had been discussing with the director, Baldoni. Heath had shown the same video to Baldoni, a man. Similarly, Lively asserts Heath inappropriate glanced at her after being invited into her makeup trailer while she was in a state of undress. Even crediting her account, there is no evidence Heath entered her trailer or did anything else for some untoward sexual reason. Before this dispute arose, Lively herself dismissed that idea, telling Heath, "I know you weren't trying to cop a look." Lively relies on the fallacious assumption that any unwelcome reference to sex or sexuality is gender discrimination. This is not the law. Exposure to overtly sexual conduct far more egregious than the alleged here is not actionable if not specifically motivated by gender. The court granted summary judgment and the Second Circuit affirmed, even where plaintiff alleged that she was the butt of jokes about an affair with a male employee. Her co-employees threatened to sodomize one another. Ooh. And someone posted a pornographic picture of a naked, obese, spread-eagled woman masturbating. It was undisputed that plaintiff was subject to unwelcome verbal conduct of a sexual nature, but the court rightly found that failure to adduce evidence that the conduct at issue was based on her sex is fatal to her claim. And then they go into a bunch of other things that state the exact same thing. I mean, you have to prove that it's based on your gender. Then they talk about Lyle is one of the court cases, is particularly on point. There, the California Supreme Court reinstated a grant of summary judgment dismissing FEHA hostile work environment claims, where a female writer for the TV show Friends presented evidence that male writers for the show had engaged in sexual antics, including their pantomiming of masturbation, graphic discussions about their personal sexual experiences, sexual preferences, and preferences in women, bragging about their personal sexual exploits. Considering the context in which the conduct occurred, the writer's room for an adult comedy show, the court concluded that there was no issue that the writers engaged in harassment because of sex. It found that both men and women engaged in sexual jokes and commentary, with no indication such conduct was undertaken to make plaintiff uncomfortable or self-conscious because she was a woman. Defendants completely remediated any allegedly offensive behavior. Lively is also unable to show pervasive harassment because any concern she raised, whether justified or not, was promptly addressed and rectified. Indeed, when filming resumed after Lively had raised a set of requests for protections, it proceeded without issue or incident. A reasonable employee would hardly be able to find their workplace to be pervasively discriminatory if their employer actively took successful steps to protect them from abuse. No harassment where plaintiff offered no facts showing any complaint she made was ignored. Lively does not claim there was any misstep or misdeed by anyone on set after her June 1st, 2023 meeting with Heath and Baldoni. Indeed, before Lively unleashed her battery of high-powered law firms, she herself redacted. Her agent visited the set and redacted. It is difficult to see how such minor alleged transgressions, all indisputably nipped in the bud while production continued, can support the massive litigation Lively has brought here. Indeed, that is precisely why one of blank. Lively cannot prove any actionable retaliation. Lively did not experience any actionable adverse action. To sustain a retaliation claim, Lively must prove, among other things, that she suffered an adverse action. Under Title VII, an adverse action must include conduct that would dissuade a reasonable worker from making or supporting a charge of discrimination. California's FEHA statute and 1102.5 of the California Whistleblower Statute, upon which Lively relies, defines a qualifying adverse action even more narrowly. In the footnote, it does say, to create the appearance of ongoing misconduct, Lively alleges the harassment has continued in the form of a coordinated campaign to cast Miss Lively in a false light. That is at best a retaliation claim, not a sexual harassment claim. Lively fails to show that the so-called smear campaign was based on her gender, nor would such a campaign constitute an adverse employment action, a term that is defined more narrowly under substantive Title VII law than for retaliation claims. The California FEHA statute require that the adverse action be employment related. That is, it must materially affect the terms, conditions, or privileges of employment. Lively did not suffer any employment-related adverse action. No aspect of Lively's employment changed for the worse after she presented her list of requested protections. She was not demoted, sidelined, or paid less. To the contrary, her power in the workplace and control over the production both expanded dramatically by her own account. Among many other things, no reasonable juror could find that Lively suffered an adverse employment action in any traditional sense. Rather than retaliate against her, defendants acceded to her every demand, providing her with a career. And I'm sure this is the PGA or something, right? The only proven publicity efforts were reasonable defensive measures. In lieu of a traditional adverse action, Lively claims that the retaliation against her took the form of a barrage of negative publicity outside the workplace and after all of her on-set work was done. Nothing defendants did can fairly be described as retaliation for Lively's engagement in any protected activity. Instead, Baldoni and Wayfarer were reasonably attempting to protect themselves in response to an onslaught of vicious negative publicity launched by Lively and her famous husband. Defendants were exercising First Amendment and due process rights, not stepping on Lively's earlier exercised rights to voice concerns in the workplace by which they had honored in full. Even if defendants' conduct in late 2024 somehow could stretch back to workplace concerns raised over a year before, there would still be no actionable harassment. This court knows well that parties accused of harassment are permitted to defend themselves. No reasonable employee should expect the employer defendant would simply surrender in the face of litigation. An employer is entitled to undertake reasonable defensive measures against an employee's charge of discrimination. Defendants' publicity efforts, even if construed in their worst possible light, are precisely the type of reasonable defensive measures outside the scope of actionable retaliation. Then in the footnote, it says, for the same reasons, defendants' lawsuit against Lively cannot support her retaliation claims, as this court recently held, to protect an employer's due process and First Amendment rights. An employer's counterclaim cannot be deemed an adverse action if it is filed without a retaliatory motive and with a reasonable basis in fact or law. It neither against the law nor retaliatory for Baldoni to put out positive press about himself or to attempt to mitigate or suppress any negative stories that may arise. That is classic PR activity, nor is pointing journalists to pre-existing negative coverage of Lively actionable. In Hughes versus 21st Century Fox, the defendant employer was accused of leaking a false narrative to the National Enquirer about the plaintiff's affair with her boss to preempt any action plaintiff would have taken to expose her claims that the boss raped'd her, as well as the discrimination and blacklisting that she suffered. Even in that ugly context, the court dismissed the retaliation claim, holding that any contact with the National Enquirer was not an adverse action under the anti-discrimination laws, but rather a colorable defense to protect defendants' business in the face of plaintiffs' inflammatory allegations. And then there's other court cases that they also bring up indeed. Here, Lively has been unable to identify any instance in which any defendant provided false information about Lively to any member of the press or to any social media influencer. Lively has never asserted defamation claims against Abel, Nathan, Tagg, or any other member of Wayfarer's PR team. Her defamation claims against Wayfarer, Heath, and Baldoni conspicuously failed to identify any statements made in August 2024 when the alleged smear campaign was supposedly in full swing. In the footnote, Lively also claimed defendants engaged in sophisticated digital warfare against her. Although Lively will no doubt assert the facts are contested, discovery establishes that digital warfare never happened. In August 2024, long before this dispute, Baldoni repeatedly asked his PR team if they were using bots or fake accounts to foment negative sentiment against Lively, and they assured him they were not. Then they have some posts here that are blanked out. Some posts are not. Such posts are not false by any measure. No one has disputed, however, that the interview actually occurred. The Second Circuit emphasizes that context matters when assessing retaliation claims, just as it does for substantive harassment claims, and a plaintiff's own behavior in the face of purported retaliation has to be considered. Lively indisputably started the publicity fight, and her reaction to even the hint of any defensive response showed she remained an eager participant on that battlefield. I love that. Lively indisputably started the publicity fight, and her reaction to even the hint of any defensive response showed she remained an eager participant on that battlefield. As early as August 9th, 2024, virtually the same day Lively claims the purported smear campaign, 4 days later, Lively and her team filed a bogus lawsuit in New York State Court and then subsequently worked with the New York Times to publish a 4,000-word article about Baldoni's purported misconduct based on numerous private and cherry-picked text improperly seized from Jen Abel's phone. This aggressive response itself shows the media activity transcended not only the workplace, but the bounds of workplace anti-discrimination laws. Lively cannot prove any protected activity was the but-for cause of the alleged smear campaign. Lively's retaliation claim also fails for the separate and independent reason that she cannot prove any temporal or causal proximity between the defendant's alleged publicity efforts and the list of protections she presented many months before. Then they're talking about there has to be some kind of link between this and that, right? There wasn't. There is no temporal proximity between any claimed protected activity and an alleged adverse action. It is undisputed that Lively faced no real consequences for at least 8 months after presenting her protections demands. On the contrary, filming resumed, including filming all of Lively's intimate scenes without incident, and she alleged no act of retaliation during the subsequent months of editing. Lively cannot prove a proximate cause. Significant intervening events between Lively's claimed protected activity and the alleged smear campaign also destroy any inference of causation, especially the but-for causation required here. It is ridiculous to suggest, but for Lively's airing of protection some 8 months earlier, defendants would have hired PR professionals to help manage their reputations. Defendants would have reacted to Lively's onslaught of negative press against them, even if no concerns about their on-set behavior had even been raised. They had a legitimate interest in protecting their reputations and the reception of their film after Lively isolated Baldoni from the rest of the cast and snubbed him at the film's premiere. These developments eviscerate any interference of the but-for causation relating to events in the distant past. Lively was an independent contractor, not an employee. Title VII covers employees, not independent contractors. Woo! California Labor Code 1102.5 is no broader. By its plain terms, it does not protect independent contractors. Lively, a world-famous actor who ran her own business empire and relied on lawyers to negotiate a detailed contract on behalf of a specialized LLC for her work, plainly wasn't a standard employee. Lively was not beholden to any employer. She controlled the terms and conditions of the work she performed to an extraordinary degree. She moved the location of the film, changed the filming schedule, led meetings at her own personal residence, and demanded numerous terms and conditions without which she refused to go forward. If sexual harassment law is designed to address a power differential, her star power gave her the upper hand. She came to exercise such immense control that, I wonder if that's that she fired the person, In determining whether an individual qualifies for an employee under Title VII, courts look to 13 non-exhaustive factors drawn from common law. And then they go over the 13 factors, which are: did any defendant have a right to control the manner and means by which the product is accomplished? The answer is no. Lively exercised control at every turn. Was a high level of skill required for Lively's work? Yes, she's an A-list actor, Who was the source of the instrumentalities and tools? Lively herself was the primary one. Who chose the location of the work? Lively did. She switched the work from Boston to New York. What was the duration of the relationship between the parties? And could any defendant assign additional projects to Lively? The relationship was limited. Did Lively have discretion over when and how long to work? Yes, that was an extensively negotiated aspect of the offer letter. What method of payment was used? Lively's loan-out entity was paid her minimum guaranteed payment in 6 installments pursuant to an escrow agreement. And then there would have been additional bonuses. What was Lively's role in hiring and paying assistants? It was extensive. Were defendants in business, and was the work part of their regular business? Yes. Did Lively receive employment benefits like health insurance? No. How was Lively treated for tax purposes? Not like a standard W-2 employee as required by New Jersey law for all films shot in the state. It Ends With Us movie withheld a 6.37% tax from its payment to Lively's loan-out entity, but it did not withhold federal, state, or local income tax or Social Security or Medicare taxes. Moreover, the very fact that Lively now claims $1.6 million times 3 or whatever it is. I mean, it's redacted here, which is ridiculous. In lost profits for her various companies demonstrates that she was in business for herself, not for any defendant. Lively cannot prove a failure to investigate claim. Lively asserts that It Ends With Us and Wayfarer employer entities violated two provisions of FEHA, California Government Code 12940 and 12940K, by allegedly failing to take reasonable steps to prevent an investigation harassment regarding their employees. Lively cannot assert claims under 12940K, which by its terms, as relevant here, is strictly limited to the employer-employee context. For an employer to fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. In any event, Lively's claims that defendants failed to prevent or investigate harassment would fail on the merits under either provisions because she cannot establish the elements of such a claim, namely that there was in fact a substantive FEHA violation, defendants failed to take reasonable steps to prevent it, or that any such failure by defendants caused Lively any harm. First, insofar as nothing Lively experienced rose to the level of actionable harassment or retaliation, defendants had no corresponding obligation to prevent or investigate. Second, undisputed facts show defendant took all reasonable steps to prevent harassment from occurring, thereby fulfilling their statutory obligations. The reasonableness of an employee's measures depends on the context. Then they give a whole bunch of laws and cases about that. Wayfarer took each of these measures. It had a separate HR department as well as an employee handbook with clear anti-discrimination, harassment, or retaliation policies. Pursuant to those policies, individuals who believed that they had experienced harassment were invited to discuss their concerns with their immediate supervisor, any member of management, or human resources. It Ends With Us movie also held an anti-harassment training administered by an outside law firm during pre-production, and provided call sheets with a hotline for workplace complaints. So really, if Blake Lively claims that she was being repeatedly sexually harassed, she had many outlets to go to report this behavior. Lively may argue defendants failed to act reasonably because no formal investigation into issues she raised took place, yet Lively herself conceded it was reasonable for defendants to forego any investigation. Her lawyer offered a proposed list of protections in lieu of a more formal HR process. The legal significance of her specific request not to investigate is that it shows defendants' alleged decision not to do so was perfectly reasonable. No formal investigation would have made any difference because defendants simply acceded to Lively's requested protections and demands. Filming continued thereafter without issue or incident in what Lively described as a completely safe and professional environment. No deficiency in the remedial apparatus of Wayfarer or of It Ends With Us movie contributed to Lively's alleged harm. She claims she was injured primarily by an alleged smear campaign that took place well after Wayfarer and It Ends With Us movie were no longer responsible for supervising on-set behavior relating to the film. Lively cannot prove aiding and abetting claims, count 7. Lively claims Abel, Nathan, and Tag aided and abetted harassment and retaliation in violation of FEHA. This claim for secondary liability cannot stand because there is no primary liability. For reasons stated above, no actionable harassment or retaliation occurred. The record is especially deficient as to any claim that Abel, Nathan, or Tag aided and abetted any harassment. That alleged conduct occurred during or before June 2023. Right, so like they weren't even there, so how could they have aided and abetted the harassment? Nathan's company Tag was not retained until August of 2024, more than a year later, and there is no evidence that Abel substantially assisted or encouraged anyone to sexually harass Lively at any point in time either. Lively's contract claims, count 8 and 9, fail. Lively's contract claims against It Ends With Us movie and Wayfarer are based on two putative agreements that she calls the Actor Loan-Out Agreement, the ALA, and the Contract Rider Agreement, the CRA, but neither is enforceable by Lively. The ALA was expressly subject to multiple conditions precedent that there were never fulfilled and no final agreement was ever reached or signed with respect to its material terms. The CRA was, by its terms, to be incorporated into the unexecuted ALA as an amendment. It was therefore subject to the same unsatisfied conditions and incomplete information, and was also not independently supported by valid consideration. Even if the ALA and CRA were enforceable, Lively's claims would still fail for multiple reasons. Lively cannot enforce either alleged agreement. Lively cannot enforce the actor loan-out agreement. Any condition in a contract must be performed before the promisor's duty of performance arises. Before liability can arise on a promise qualified by conditions expressed or implied in fact, such conditions must be fulfilled. It is undisputed that the parties never executed the ALA nor agreed on its final terms, and Lively never signed the inducement, each of which was a condition on It Ends With Us obligations, nor these express conditions waived. Indeed, It Ends With Us movie representatives flatly refused to remove these conditions. Interesting. And then it's blank. So I guess they were asking to remove them and they were like, no. It Ends With Us movie behavior was a far cry from conduct so inconsistent with an intent to enforce the right as to induce a reasonable belief that such right has been relinquished, as it required to find a waiver of a contractual right. And then there's something redacted, but it says, if anything, redacted is compelling evidence Lively knew It Ends With Us movie had not waived compliance with the conditions precedent. For substantially the same reasons, the draft ALA was never a binding agreement. Here, the undisputed facts show the parties communicated an intent not to be bound absent full execution via 1. The clear condition precedent language in the draft of the ALA, which It Ends With Us movie refused to remove. It Ends With Us movie continued efforts to obtain Lively's signature through July of 2024, and her continuing refusal to provide it as a manifestation of her acceptance. And 3, the entire agreement provision of the draft ALA, as well as the similar provisions in the standard terms. So they're saying they are just going back and forth on the contract. It was never signed. It was never agreed upon. And even the sexual harassment provision, the provision Lively claims was breached, remained subject to revisions when the last draft was exchanged. Lively cannot enforce the contract writer agreement. Lively cannot enforce the CRA even though it was fully executed because it was expressly made part of the ALA, and Lively's right to enforce the CRA was subject to the same unsatisfied execution conditions present in incomplete formation of that argument. The CRA was not intended as a standalone agreement independent of the ALA. Rather, by its terms, it provided additional terms and conditions in connection with artist services and was deemed incorporated into the ALA. They do talk a lot about those contracts, but just for the sake of time, because this video is already running a little bit long, but they do make very good points about the contract not being signed and then also just what that means and the differences between the contracts. But I kind of summed it up with the first little paragraph. Even if the ALA and CRA were enforceable against the entity defendants, Lively's breach claims would fail as a matter of law. The entity defendants did not engage in a conduct arising to a breach. Then they just say there was no breach because, as discussed above, Lively does not come close to establishing a genuine issue of fact as to any such claim. The entity defendant's alleged conduct cannot constitute a breach because Lively failed to provide notice and an opportunity to cure. Lively's breach claim also fails because she failed to provide 30-day notice and an opportunity to cure as required by the ALA's company breach provision, which also governs the incorporated CRA. That provision states that no act or omission of company It Ends With Us movie hereunder shall constitute an event of default or breach of this agreement unless artist Lively shall first notify company in writing setting forth such alleged breach of detail, and company shall not cure the same within 30 days after the receipt of such notice. Lively never provided the requisite notice and opportunity to cure before asserting her breach of contract claims. To be sure, Lively's attorney sent a cease and desist letter on December 20th, But that letter was not addressed to It Ends With Us movie as required by the contractual notice provision and did not mention any alleged breach of the ALA. In any case, Lively filed her breach claims on December 31st, only 11 days after sending the cease and desist letter, far less than the contractually mandated 30-day period. Because there is nothing in the record showing Lively provided It Ends With Us movie with such notice of breach, or that she accorded It Ends With Us movie 30 days to cure the alleged breach as expressly required under the agreement, there was no cognizable breach by the entity defendants. Even if notice were provided via Lively's counsel November 2023 email, the entity defendants indisputably cured any potential breach based on alleged sexual harassment. It is undisputed that when work resumed after the writer's strike and following receipt of Lively's list of protections, there was no reoccurrence of any alleged impropriety. Work on the set proceeded without issue or incident, without a single concern or raised about even a single item that might give rise to a potentially hostile work environment. As a result, any source of discomfort that could arguably rise to a claim for sexual harassment had been completely cured. Per the notice and cure provision underlying both the ALA and CRA, any noticed sexually harassing conduct having been cured cannot constitute a breach. Even if there was a breach, okay? Even if there was a breach, they're saying, even if there was a breach by It Ends With Us movie, Wayfarer would not be liable because Lively cannot establish alter ego liability. Lively's breach claims against Wayfarer suffer from an even more obvious defect. Wayfarer was not a party to the punitive agreements and therefore cannot be liable for any breach thereof. Lively's explicit contention that Wayfarer is liable for breach of It Ends With Us movie's alter ego is unavailing because a member or manager of an LLC cannot be held liable for the debts, obligations, or other liabilities of the LLC, whether arising in contract, tort, or otherwise, solely by reason of his status as a member or manager. Lively cannot prove that Wayfarer should be liable as It Ends With Us movie's alter ego. There was no manipulative conduct by Wayfarer or It Ends With Us movie. Lively was represented by sophisticated entertainment counsel during her negotiations with It Ends With Us movie, and her counsel knew that the contractual counterparty would be a designated production service entity. Ultimately, It Ends With Us, not Wayfarer itself, as it is customary in the film industry. Indeed, it was Lively's counsel who redlined the offer letter to substitute It Ends With Us movie as producer, whereas the initial draft had defined producer as Wayfarer Studios or designated production service entity. Any suggestions that it was manipulative or bad faith for It Ends With Us movie to be the counterparty is also belied by Lively's own use of a loan-out company, Blakel Inc., as counterparty to the alleged agreements. They go on to say that just because Wayfarer participated in the movie, It Ends With Us was its completely own entity. Most of the staff was hired outside of Wayfarer. Like, there were some Wayfarer employees, but they had their own bank accounts, their own funds, their own counsel, their own, everything. So they were their own entity just because, it was also through Wayfarer. Lively's alleged damages for breach are barred by the limitations of damages. Provisions of the ALA are not cognizable in any case. Even if Lively could establish a triable fact on her breach of contract claims, most, if not all, her asserted damages would be barred by the ALA's limitation on damages clause, which exclude consequential and or incidental and or special and or punitive damages. So they're saying in the contract that Lively's trying to use that she didn't even sign, she can't even claim any of these damages. Here, little if any of Lively's asserted injury consists of general damages, damages that flow directly and necessarily from a breach of contract or that are a natural result of a breach. Rather, nearly all of Lively's asserted damages are paradigmatic, consequential, incidental, or special damages, secondary or derivative losses arising from circumstances that are particular to the contract or to the parties. Lively's claims, for instance, that defendants' conduct caused associated businesses to suffer, which is, I'm sure, her Betty Boos and what's the other one? Blake Brown, which Lively refers to as lost earnings from the speculative loss of entertainment deals with third parties. Lost earnings are, of course, a component of lost profits. Lively also claims blank from reputational harm, which appears to be simply double counting of her alleged future lost profits. None of these damages flow directly or necessarily from the entity defendant's alleged breaches. They are instead secondary or derivative losses based on Lively's particular circumstances, namely her expectation of attaining income from her affiliated business and subsequent entertainment-related contracts with third parties. Under California law, lost profits can constitute direct damages only where the profits lost were due under the breach contract itself, not future or unidentified contracts. Lively does not contend that any of her lost profits are monies owed by defendants under the contract. Thus, the lost profits Lively seeks are best characterized as consequential, not general damages. Thus, Lively's lost profits, lost wages, and reputational harm are all consequential, incidental, or special damages and barred under the limitations of damages provision. Lively only alleged damages that do not fall into the bucket of consequential, special, incidental, punitive damages are all alleged pain and suffering, physical pain, and humiliation. It is unclear whether Lively contends that these are proper damages for her breach claims as opposed to her tort claims. To the extent that she does, her contention is barred because such damages are not available for breach of contract. Thus, Lively has failed to satisfy damages, which is a necessary element for breach of contract. Lively's contract claims are improperly duplicative. Even if Lively's contract claims had merit, they would be subject to dismissal because they merely duplicate her harassment and retaliation claims. Tort claims generally are not duplicative of contract claims because tort claims offer a separate measure of recovery. However, a claim is duplicative if it seeks the same damages or relief already sought by another claim. Here, however, Lively's theory of damages for her contract claims and her statutory tort claims are entirely overlapping. Lively is not entitled to double recovery for the same injury by pleading both tort and breach of contract claims. Because she cannot establish any independent damages for the alleged breach, her contract claims should be dismissed. The defamation of false light claims, 12 and 14, fail. New York law applies to Lively's defamation and false light claims. A federal court sitting in diversity or adjudicating state law claims are now pendant to a federal claim must be applied the choice of law. And then they just say, of course, it's going to be New York law. Everything happened in New York. She's in New York. All of this smear. It's like all New York, right? So that's what they're kind of like this whole thing is about. So then there's a few pages here about just why it's New York law. And we've already gone over that so many different times. Lively's false light claims, count 12, fails. The false light claim cannot proceed because New York law applies and New York does not recognize the tort of false light invasion of privacy. Summary judgment on that claim must be entered for defendants. Lively has no standing to bring a false light claim. Even if California law were to apply, Lively still lacks standing. But the California Constitution expressly grants Californians a right of privacy and thus does not apply to Lively, who resides in New York. Lively's defamation claim, count 14, fails as a matter of law. Lively generally contends that Wayfarer, Baldoni, and Heath, through their agents, published false statements asserting that Lively's allegations of harassment filed with the California CRD and this court were false and fabricated. That is Lively's defamation claim. By definition, based entirely on statements about the litigation published after litigation commenced. This claim fails for multiple reasons. So this whole section is about Brian Freeman. Remember, she then brought Brian Freeman in saying that he was also defaming her. Lively cannot prove falsity or malice. Lively's defamation claim fails because it is premised on the conceit that her harassment and retaliation allegations are true and any contrary statement false. But as explained above, super points 1 and 2, Lively's claims and allegations do not rise to the level of harassment, and no retaliation for complaints of harassment occurred. The defamation defendant's statements denying the truth of Lively's allegations and asserting, for example, that she claims are completely false were true, or at minimum, substantially true. Lively's claim therefore fails as a matter of law. Just as significantly, defendants' alleged statements denying the truth and validity of Lively's claims and allegations were not statements of objective fact and therefore cannot constitute defamation as a matter of law. Statements about whether or not there was any smear campaign are for the same reason not actionable. Smear campaign lacks any precise, definitive meaning, such that statements denying the existence of such a campaign reflect constitutionally protected opinion. Likewise, assertion that, for example, Lively was pushing her own self-serving and selfish vendetta and her claims were outrageous and intentionally salacious are likewise precisely the sort of opinion statement that cannot be objectively proven and is therefore not an actionable basis for a defamation claim. As a public figure for the purpose of First Amendment analysis, Lively must demonstrate with clear and convincing evidence, which she doesn't have any evidence, that the defendant realized that their statements was false or that they subjectively entertained serious doubt as to the truth of their statement. Lively contends that the defamation defendants knew her allegations were accurate because they signed the CRA and knew that Miss Lively was not alone. The CRA was not, by its terms, an acknowledgement of any past wrongdoing. It was expressly forward-looking. But even accepting Lively's spin on the document, it shows at most that defendants knew complaints were raised and that the complaints were true. The allegedly defamatory statements were absolutely privileged. Lively's defamation claim also fails because it is based on statements that are absolutely privileged under the New York law. New York's fair report privilege protects any fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding. Yeah, I mean, the fact that she can run to the New York Times and print that whole story, but Brian Freeman can't be on the Megyn Kelly show, get out of here. Here, the post-litigation statements Lively claims were defamatory all merely repeat allegation defendants had already asserted or would assert in this action, namely that Lively's allegations of harassment and retaliation were false and self-serving and could not constitute actionable claims. Moreover, permitting a defamation claim to proceed to trial based on an attorney's blanket denial of serious accusations against his clients would raise serious First Amendment concerns. For that reason and others, New York courts have extended the fair report privilege to comments made by attorneys to the press in connection with the representation of their clients. We are almost there. A couple of pages left. Lively's conspiracy claim count 15 fails. Lively's conspiracy claim fails for several independent reasons. First, there can be no claim of conspiracy, whereas here there is no actionable underlying tort. Second, even if Lively had a viable tort claim, her conspiracy claim would be entirely duplicative of it and should be dismissed on the ground as well. Third, outside of tort liability, no claim for conspiracy will lie. A breach of contract may not serve as the basis for a civil conspiracy claim, nor does New York civil conspiracy law extend to Lively's federal and state statutory claims. There is no basis for liability against defendant Steve Seretz. This is the last part. I thought it was pretty cool that Steve put himself last. I mean, it just goes to show you like how unselfish he is and that he was last because, you know, he is kind of funding this entire thing and he could have put himself first to make sure that like the judge really like, hey, sees it and like gets him out of here. But that just goes to speak to his character, honestly. Lively alleges only 2 claims against Steve Seretz, false light and conspiracy. For the reasons discussed, these claims fail. Even if these claims could proceed against any defendant, no reasonable jury could find Seretz liable. His exceptionally limited involvement confirms why, and the record is devoid of any facts implicating him in either claim. Seretz is the majority investor in Wayfarer Studios and provides the studio with financing. He played no role in the production or marketing strategy of the film, visited the set only twice, and played no role overseeing press concerning the film or this dispute. Lively's claims against him are predicated on overblown comments that are taken out of context. For example, Lively alleges Seretz stated he would spend $100 million to ruin Lively and her family, but the discovery record confirmed Seretz did not make any such comment, and at all times was focused only on defending himself and the studio. That's her biggest claim against Saritz. And now they're saying after discovery, he actually never said that at all. So she's been literally lying. Like, oh my God. Lively also quotes a surreptitious recording of Saritz in which he states, "There will be 2 dead bodies when I'm done." But as the recording makes clear, Saritz was speaking only in metaphorical terms, left out Lively's allegations and Saritz's immediately clarification that he meant not dead, but you're dead to me. Saritz was focused solely on making sure the studio was protected from Lively's attacks and not attacking Lively, and he disclaimed any intent to harm Lively as not the world I want to live in. Such comments without any evidence of any specific follow-up conduct are insufficient to support any of the claims in which Saritz is named. Several aspects of Lively's damages claims must be dismissed. Lively lacks standing to assert claims for lost profits or royalties. Lively claims blank of lost profits associated with 2 non-parties, as well as royalties flowing from those entities. Lively is merely an indirect shareholder of these entities and not the direct beneficiary of any royalties flowing therefrom. As such, she has no basis to claim any such damages or to recover losses allegedly suffered by these entities. A shareholder cannot sue in her individual capacity to redress wrongs inflicted upon a corporation in which she holds stock. Courts routinely reject claims like Lively's in which individuals seek redress for corporate damages, including lost profits. Lively and the businesses she works with are not interchangeable. An individual lacks standing to sue when the alleged injury is based on an injury to a corporate entity. Lively cannot recover speculative lost profits. Even if Lively had standing to seek damages on behalf of these distinct corporate entities, she does not. The court should still reject her demand for lost profits. Lost profit damages are too speculative, whereas here they arise from entirely new business ventures without any proven record of financial performance. So they're saying because these businesses were new, they don't know what they were supposed to do or not do. So it's a new business. Therefore, because it is any new business, the court strongly does not exist a reasonable basis of experience upon which to estimate lost profits with the requisite degree of reasonable certainty. Both New York courts and courts in the Second City have dismissed claims for lost profits where the pleadings suggest that an award of lost profits would require an unreasonable level of speculation. So not only does she not own the companies, but they're brand new. So we would have to be like, it's a guessing game of how much you lost in profits. Conclusion. Finally, for the foregoing reasons and those stated in defendant's motion for judgment on the pleadings, this court should grant summary judgment in the Wayfarer party's favor on Lively's claims. And then there's all the lawyers. So great job to like all the lawyers. I mean, a ton of them at this point. There you have it. Wowzers. I just checked the time. This video now is running over 2 hours. I think after I edit it, it'll probably be maybe like an hour and a half. There it is though. That's all the information, you know. I'm going to edit this, upload it right away, and then go over all the other documents, all the other exhibits. Stay with me. I'll be back for more. I love you so much. I hope you enjoyed the video. Please subscribe, comment, all of that stuff, and I'll talk to you soon. Bye.